The Supreme Court just fired a wake-up call heard in every corner of the nation, and it wasn't gentle. The court has agreed to hear a gun rights case that could let people with criminal records possess firearms legally. By an overwhelming 8-to-1 tally, the justices just bulldozed one of the country's most aggressive pro-gun statutes, and the aftershocks could reshape how Second Amendment fights play out. For years, this wasn't simply a ruling, it was a full-scale reset on how far a state can go to resist federal firearm rules. So, what unfolded? Missouri enacted a statute claiming that chunks of federal gun regulation simply didn't apply inside its line. The Supreme Court just cut in and said, slow down. The stakes are massive, the signal unmistakable. If you care about gun ownership, state power, or where Washington's reach ends, you'll want to track what happens next, because this move doesn't stop at Missouri. It's a warning flare for every Second Amendment sanctuary saint, and the ripple has only started. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Part 1. 8-to-1 Shockwave. The court just issued an order that blindsided both sides of the firearms debate. In a lopsided 8-to-1 vote, the justices rejected Missouri's emergency plea to let its controversial gun statute stay in force, while lower courts kept reviewing it. Missouri wasn't asking for a final thumbs up, it only wanted the green light to enforce the measure for the moment. The answer was a flat no. Only Justice Clarence Thomas stood with Missouri. The remaining 8 even well-known gun rights defenders Alito and Gorsuch denied the request. That alone rattled gun owner circles. Yet, there was a wrinkle. Alito and Gorsuch tacked on a short statement. Yes, they agreed to halt enforcement, but the district court hadn't wiped the statute off the books, it had only barred state officials from acting under it. A fine legal hair, yet it might matter down the road. Why is the 8-to-1 split so startling? This is the same court that supercharged gun rights in the 2022 Bruin ruling and has sided with firearm owners repeatedly. Yet, when Missouri stretched a little too far with its sanctuary-style statute, even this court hit the brakes. Adding to the drama, the order arrived through the shadow docket, no oral arguments, no lengthy opinions, just a terse emergency line. That makes the signal even louder. States can't unilaterally erase federal gun rules. Not by statute, not by proclamation, not even by calling the statute unconstitutional. The Supremacy Clause still reigns for now. Missouri's measure is frozen. Federal firearm laws remain fully operative inside the state, and cops can again team up with federal agents without risking a lawsuit. Washington chalked up a major win, and every watching legislature just received a cautionary bulletin. Part 2. What Missouri actually passed. Missouri didn't merely tweak a gun rule, it lobbed a legal grenade. In 2021, lawmakers adopted the Second Amendment Preservation Act. Unlike the feel-good resolutions other states brandish, this bill carried live ammo. It attempted to nullify swaths of federal firearms regulation inside state borders. Which rules? Nearly any it disliked. Registration requirements, dealer licensing, even the long-standing ban that keeps felons from possessing guns. All were bundled together and labeled unconstitutional. But the measure didn't stop at rhetoric. It carried sharp teeth. Any state or local employee who helped enforce those federal statutes could be hit with a $50,000 penalty personally. Picture a small-town chief who lends a hand to the ATF and suddenly owes more than an annual salary. That isn't a slap on the wrist, it's financial ruin. The clause sowed chaos across law enforcement agencies. Worse, the bill never spelled out which federal provisions were void. It spoke vaguely of any regulation that infringes on law-abiding citizens without defining law-abiding. Officers froze, assist the feds and risk bankruptcy, or refuse and watch criminals walk. Most departments chose the latte. Backers hailed it as a muscular stand against federal overreach. Lead sponsor, Representative Jared Taylor, insisted Missouri was shielding residents. Governor Mike Parson echoed that the state wouldn't wait while Washington dictated lifestyles. They pointed to immigration sanctuary cities that declined to aid ICE. Yet, there's a hitch. Gun sanctuaries and immigration sanctuaries don't map onto the same legal terrain. The analogy plays well on talk radio, but in court it collapses, and that's precisely where the trouble ignited. Part 3. Anti-commandeering meets nullification. Missouri figured it had ironclad cover under the anti-commandeering doctrine, a principle the court has recognized for decades. In plain English, Washington may not press gang states into enforcing federal programs. If a state wants to sit out a federal policy, it can. ban. The court locked that in during Prince v. United States, 1997, ruling that county sheriffs needn't run Brady background checks. It reaffirmed the idea in Murphy v. NCAA, 2018, striking down a federal ban that tried to stop states from authorizing sports betting. The takeaway: states can refuse to pitch in, yet they can't rewrite federal law. Missouri's lawyers argued they were simply following that playbook, just like sanctuary cities that won't detain migrants. Missouri wouldn't lift a finger for gun statutes it despised. Reasonable on the surface, said the U.S. Solicitor General, but that's not what Missouri really did. Under anti-commandeering, a state may say, "We're out." It may not declare, "The statute is void here," or fine people who still cooperate. And that's exactly what Missouri did. Rather than step aside, it proclaimed entire sections of federal gun law null, ordered its own officers and courts to ignore them, and threatened massive fines against anyone who collaborated with federal agents. At that point, it swung from shield to sword crossing into nullification territory, and that's unconstitutional. Picture anti-commandeering as a shield that lets a state stay out of the fray. Nullification is a sword that tries to slice federal law to pieces. Missouri claimed to carry a shield, but it swung a sword, and the judiciary wasn't fooled. One district judge labeled it an unconstitutional obstruction. The Eighth Circuit agreed, reminding Missouri that legislatures don't determine constitutionality. Courts do. Under the Supremacy Clause, federal law is the supreme law of the land, binding on state judges no matter what a statute says. Missouri didn't just walk off the field. It tried to block, override, and penalize anyone still playing for the other team. That line even a pro-gun Supreme Court would not cross. Part 4. Politics collides with the streets. Missouri's statute didn't merely ignite briefs and oral arguments. It became a live drill for cops. What unfolds when a state yanks every last assist for federal gun cases? Answer: bedlam. The moment the bill took effect, officers statewide began quitting ATF task forces targeting traffickers, gangs, and violent felons. The Bureau has only about 2,600 special agents nationwide. Without local help, the net grew dangerously thin. Then came the data shutdown. Missouri's own Intelligence Fusion Center stopped feeding records to Washington. PDs ceased uploading ballistics reports into the national database that links shell casings to other shootings. Translation: they locked crime-solving tools in a closet. Evidence that might have closed homicides in neighboring states sat unused. Let that sink in. The fallout wasn't hypothetical. It showed up in real cases. In Poplar Bluff, a man fired on his ex-girlfriend. Normally, the case would ride the elevator to federal court, especially if the shooter was already a prohibited possessor, but the chief didn't refer it, fearing the $50,000 penalty. Elsewhere, troopers gathered roadside casings after a highway shooting, yet withheld them from the national network. The leads died on a local shelf. Worst of all, a Missouri officer was murdered. Customarily, the weapon trace would be automatic, yet state investigators hesitated, worried the new law criminalized basic cooperation. For a moment, justice for a fallen cop stalled because of a state fine. Ordinary residents might not have felt a difference, no new purchasing rights were created, but the measure carved a loophole through which prohibited possessors slipped unnoticed. Police had their hands tied, and offenders knew it. Now that courts have enjoined the statute, cooperation can restart. Cops can rejoin task forces, share intel, and rebuild relationships that once made gun crime enforcement formidable. The brawl was political, yet on the asphalt the price was blood and delayed justice. Part 5. The national map gets redrawn. Missouri was the battlefield, but the court's order echoes coast to coast. By early 2024, more than a dozen states and roughly 2,000 counties had pronounced themselves Second Amendment sanctuaries. Nearly all were symbolic declarations. A handful curbed use of local funds, yet none matched Missouri's fines and outright nullification effort. That's why the 8-to-1 order landed like a warning flare. Even with a conservative majority, the court signaled it will not sit idle while states attempt to override federal authority. Missouri has already answered. In early 2025, legislators filed a revised draft. This version deletes the clause branding federal statutes unconstitutional, but keeps the ban on assistance and the $50,000 penalty for officers who help the feds. Whether that watered-down text survives review remains an open question. Critics call it the same wolf in woollier heavier clothing. Supporters insist it threads the needle between state autonomy and national supremacy. Either way, fresh litigation looms. Other capitals are watching. Alaska, Idaho, and Kansas are already retooling bills, hoping to dodge Missouri's wrecking ball while still thumbing noses at Washington. Here's the ironic twist. Red states pushed gun sanctuary measures in the name of freedom. Blue cities once pushed immigration sanctuary policies for parallel reasons. Different politics, identical constitutional ceiling. The Constitution draws the same line for both. National groups are regrouping. The NRA and Gun Owners of America backed Missouri and left disappointed, yet they're not surrendering. The Alito-Gorsuch concurrence hinted that narrower non-cooperation language might still float. Meanwhile, Everytown and Giffords are popping corks. They had warned that Missouri's experiment left gaping enforcement holes and view the order as a public safety win. But the bigger question hovers. If enough states refuse to play ball, does Washington have the manpower to enforce gun laws solo? The ATF and FBI don't keep thousands of spare agents in storage. Statutes on parchment are just that, parchment, without partners in city halls and sheriff's offices. The court didn't merely swat Missouri. It redrew the atlas for every legislature testing federal power. Missouri fired a bold shot. The court drew the line. Now, every state knows precisely where that line sits. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.